Welcome everybody, wherever you're joining from around the world or whether you're watching this virtually. My name's Beck Markey-Towler. I'm a research fellow at Melbourne Climate Futures at the University of Melbourne, and I'm also a PhD candidate in the Melbourne Law School. We're delighted to have our presentation today from Aileen, but just before we get started with Aileen's presentation, I'd like to acknowledge the people who are the traditional custodians of the land on which we're zooming in from today. So I'd like to acknowledge and pay respect to elders past, present and emerging of the Kulin Nation, and extend that welcome to any First Nations people here today. So today we're delighted to have joining us Aileen Yildiz-Norda. And Aileen is a postdoctoral researcher at the Lisbon Public Law Research Centre at the University of Lisbon. She has over 7 years of experience in research and consultancy in public international law and corporations law, including aspects on climate change, sustainability and ESG topics, including sustainable finance. And her current research project is funded by the Swiss National Science Foundation, and it's focusing on sea level rise. She has a PhD in law, an LLB, an LLM, and an LLB with honours. So we're delighted to having her join us today to give a presentation on when balance sheets pollute, litigating the climate change related human rights impacts of financial institutions. I'd encourage you to pop your questions as we go along in the chat, and it would be great to have an engaging conversation after today's presentation from Aileen. So Aileen, I might hand it over to you now to kick things off.
Thank you so much, Beck. I'll just share my screen, and if you could let me know if it looks good, that would be great.
That looks great, Aileen.
Okay, thank you so much. So good day, everyone. I'm very happy to be here today and to present my research on climate litigation. I'd like to start by thanking MCF for hosting me. In particular, many thanks to Theo, Bell, and Rebecca, as well as other members of MCF for organizing this event. So today we're going to talk about a very interesting, extremely dynamic, and an increasingly popular topic. That's climate litigation. We're going to specifically home in on a type of climate litigation which remains insufficiently examined. That's climate litigation in the financial sector. Within this subcategory, we're going to look at the cases that involve human rights claims. And then there'll be additional scoping factors, which we will talk about later on in the presentation. So I'll begin by providing some background context. Next, I'll delve into my research, explaining the research question, methodology, and the data set. Then I'll analyze the data set. This will be particularly engaging and technical. I'll try to ensure that you can follow along, even if you don't have a legal background. Lastly, I'll wrap up with insights on future trends and research directions, and I hope these closing thoughts will spark questions for the Q&A session. So let's get started with a question. Have you heard of the UN human rights complaint against Saudi Aramco and its financiers? Now, if you have, that's great. That means you already have some idea about today's topic. And if you haven't, that's also great, because here's more information about this complaint. So in June 2023, 5 UN human rights mandate holders issued what is called special procedure communications to Saudi Aramco, its 12 financiers, and the home states of the financiers. Saudi Aramco is a major oil and gas company responsible for 4.33% of global greenhouse gas emissions. The UN human rights experts communicated that the 12 financial institutions supporting Saudi Aramco's activities are allegedly contributing to adverse climate change-related human rights impacts, contrary to their own human rights responsibilities. Now, clarifying these responsibilities, the UN human rights experts indicated that the financial institutions that are involved here can be directly linked to adverse climate change-related human rights impacts, not just through their own operations, but also through their business relationships, such as through the provision of financing. Now, this allegation might seem counterintuitive, and you might have 2 reasons for thinking that way. First, because of the indirectness of the emissions of financial institutions. We know that direct emissions stemming from the own operations of financial institutions are estimated to be much lower when contrasted with the indirect emissions relating to their products and services, For instance, the CDP, the Carbon Disclosure Project, estimated that the emissions associated with financial institutions' investing, lending, and underwriting activities are on average over 700 times higher than their direct emissions. Therefore, financial institutions are typically portrayed as being implicated in climate change in an indirect manner, primarily through the value chain of numerous industries due to their extensive financing, investing, insurance, and reinsurance activities. Second, because of the indirectness of the relationship between a financial institution and the alleged adverse impact. Here, this argument focuses on the collective, diffuse, and transboundary nature of climate change, and the difficulty in demonstrating a connection between a particular financial activity, such as financing, and the specific activity causing an adverse impact, such as the activity of a client receiving finance. Now, I call this the indirectness problem, and civil society and affected rights holders have been trying to refute the indirectness problem. They essentially argue two things. First, the indirect emissions, referred to as Scope 3 emissions, of financial institutions are a relevant factor in determining the fulfillment of their baseline responsibility to respect human rights. Now, what is this baseline responsibility? It comes from the UN Guiding Principles on Business and Human Rights, the UNGPs. According to the UNGPs, financial institutions must not cause, contribute to, or be directly linked to adverse human rights impacts arising from their own operations as well as business relationships. Second, the direct relationship between a financial activity and an adverse impact may be demonstrated through the use of climate attribution science. This argument basically focuses on limiting global warming to 1.5 degrees Celsius in line with the Paris Agreement. To achieve that global goal, financial institutions should adopt, publish, and track short, medium, and long-term absolute emissions reduction targets and, where appropriate, relative emissions reduction targets across their entire value chain, including all indirect emissions, using a robust methodology verified by a third party. Now, this line of argument has been advanced in various forums, including before judicial and non-judicial mechanisms. For instance, a case was filed before the United States National Contact Point against Marsh for acting as an insurance broker in the construction of a new oil pipeline, the East African crude oil pipeline. The rights of local communities in particular are allegedly violated. A case was filed against BNDES, Brazil's development bank, and its investment arm for investing in high-emitting companies, which allegedly contradicts the right to an ecologically balanced environment enshrined in the Brazilian constitution. In another case filed in the UK, the claimants argued that the directors of USS, the university's superannuation scheme, undermined climate risks in a way that is incompatible with the rights to life and respect for private life. So this is the context in which my research takes place. I wanted to understand the role of climate litigation in demanding financial institutions to meet their baseline responsibility. There is limited research on this. For instance, one of the early studies was conducted by Solana in 2019. He created a typology of climate litigation and financial markets, and he also briefly touched upon fundamental rights-based claims. We also know that there's an increasing number of climate cases concerning financial institutions. Although not the earliest litigants, financial institutions are increasingly involved in climate litigation, both as respondents and claimants. We also know that since 2015, we have been increasingly observing a rights turn in global climate litigation. Jacqueline and Harry were the first to write about this. Human rights laws and standards are increasingly being used to compel governments and companies to adopt and implement more ambitious climate action. So I wanted to see whether we can observe a similar pattern in climate litigation concerning financial institutions. And a natural question that flows from this is, do we need a rights turn? Perhaps, because we have to remember that it is still largely illegal to provide financial products and services to fossil fuel projects and other high-emitting projects and clients and sectors. There are new and emerging sustainability and ESG laws, regulations, and standards. These have been possibly inadequate, because these legal frameworks are largely concerned with increasing transparency, so disclosures and reporting, and labeling, for instance, in accordance with a taxonomy or a classification system. But they still do not, by and large, level the playing field and order a global standard of conduct for financial institutions to tackle climate change. So with these questions and observations in mind, let's take a look at the methodology. I used 5 databases to collect data for our climate litigation databases. This includes the Australian and Pacific Climate Change Litigation Database managed by MCF. So congratulations on running this database. The 5th database records the OECD National Contact Point cases around the world. Now, I've mentioned the OECD and the National Contact Points a few times already. Let's briefly explain these in case you don't know what they are. The OECD is a multilateral organization. Today, there are 51 states that have joined it as members or adherents. This organization has adopted guidelines for multinational enterprises on responsible business conduct way back in the 1970s. Then a new version was adopted in 2011, and this was updated in 2023. And in 2000, a remedial function was established. This is what the national contact points are. There are 51 NCPs in the world today, 1 in each state. They hear complaints about individual cases relating to the implementation of the guidelines. Unlike a court, they cannot issue a legally binding decision. They provide a special type of mediation or conciliation. So getting back to the methodology, in the first phase, I collected data from the 5 databases I mentioned. I applied selection criteria. Climate change had to be discussed in all cases. Each case had to involve at least one party of a financial nature, which I construed really broadly to get a good understanding of the big picture. I restricted the venue, so I was only interested in cases that were brought before a court or an NCP. I also collected cases in various stages, so they could be concluded, ongoing, or on appeal, and this has resulted in a collection of 49 cases. Next, I filtered this data to see which cases discussed human rights, and that resulted in 21 cases. I filtered that further. This time, I wanted to make sure that the financial entity involved in the case was a business enterprise. And this is because the UNGPs are applicable to business enterprises, irrespective of size, structure, operational context, or ownership. The business enterprise in question may be owned or supported by the state. And that gave me 14 cases. The study has limitations which merit consideration. Data availability across 5 databases may create bias towards certain jurisdictions. The global climate litigation landscape evolves fast, so it's difficult to make conclusive observations, and there are a lot of cases that are pending. And climate litigation may not show the full picture. A clear example of what could be left out is the political activism of some financial institutions. This is demonstrated in their recent support for an orderly phase-out of all fossil fuels in a just and equitable way. You can check out the document titled "The Transformation is Unstoppable," which is on the right side of this slide. So while some financial institutions may genuinely advocate for global regulatory efforts aimed at leveling the playing field to direct financial flows towards a low-emission pathway, various interrelated factors, including political opposition, lobbying influence, applicable rules and regulations, armed conflicts, the inflation crisis, and other global events, limit immediate and impactful change in financial markets and industry. But despite these limitations, the cases in the dataset illuminate a stark reality. Fossil fuel companies, buoyed by backing from financial institutions worldwide, continue to reap astronomical profits and expand their operations, even as the global temperature reaches a critical 1.1 degrees Celsius rise. So the big picture that emerges from the dataset with 49 cases is that climate litigation in the financial sector has at least a 22-year history. One of the earliest recorded cases was filed in 2002 in the US. It challenged the financial support provided by US Export-Import Bank and the Overseas Private Investment Corp for international fossil fuel projects. This legal action was grounded in statutory obligations mandating environmental impact assessments. By 2008, insurance companies had entered the courts seeking declaratory judgments that they were not obligated to defend or indemnify policyholders in climate-related lawsuits. Subsequent years witnessed the evolution of shareholder activism and legal actions targeting employees' pension plans. Courts were particularly asked to interpret fiduciary duty in these cases to accommodate climate risks and actions. Simultaneously, the escalating concern for consumer and investor protection against greenwashing claims prompted regulatory and supervisory bodies to initiate investigations, some of which resulted in court actions. Regulatory challenges, both pro and anti-climate and ESG, have also been increasingly recorded, especially in the US. Now, 84% of the cases were filed after 2015, coinciding with the adoption of the Paris Agreement. Cases were filed in numerous jurisdictions, most notably in the US, and 8 cases in Australia, followed by the UK and Brazil. The regional EU courts also received 3 cases. Most cases relate to financing activities, followed by pension activities, and the rest of the cases concern insurance activities, greenwashing, and regulatory challenges. A slight majority of the cases were filed against companies, closely followed by cases against governmental agencies. A minority of the cases targeted both, whereas in 2 instances, climate activists protesting against a commercial bank's activities were criminally prosecuted. Excuse me. So filtering the cases that discussed human rights, we see that the first 3 cases were actually filed before the NCP mechanism. The baseline responsibility of financial institutions to respect human rights served as the bedrock for these claims. In 2019, the first recorded cases appeared before the courts. These cases targeted the biggest multilateral financial institution in the world, that is the European Investment Bank, and a sovereign pension fund, the Luxembourg Pension Fund. These claims relied on the right to access environmental information pursuant to the Aarhus Convention to demand climate-related disclosures. In 2020, Brazilian courts received 2 cases, resulting in landmark rulings against the government, finding the paralysis of public funds to combat climate change and deforestation an unconstitutional omission. Cases filed in that same year against the UK Export Finance, ANZ Bank, and Credit Suisse did not yield similar findings of climate rights abuses. Filed in 2021, the USS case faced a dismissal similar to the Client Earth and Shell plc case in the oil and gas sector. Both lawsuits were filed in the UK and sought permission for what is called a derivative action against company directors to enforce duties. The UK courts hesitated to view the derivative action mechanism as a tool for advancing a policy agenda or to challenge the investment decisions of company directors, emphasizing alternative routes such as a breach of trust claim as potentially more appropriate. On the other hand, the Belgian National Bank case filed that same year led to a concrete policy change, tilting the European Central Bank's purchases under the Corporate Sector Purchase Program, the CSPP, towards issuers with a better climate performance. In 2022, a claim against Korean public financial entities was filed, alleging that support for a gas reserve in Australia contradicts the right to a healthy environment. The BNDES case filed the same year invoked the right to an ecologically balanced environment. And finally, 2023 saw the filing of cases against Marsh, Eni, and BNP Paribas. So filtering the data set further, we have 14 cases where business enterprises are involved in the proceedings. These cases discuss a diverse range of human rights, including the rights to life, health, food, water, healthy environment, property, access to information, indigenous rights, and freedoms of expression, assembly, and association. All cases address the business relationships of financial institutions in 2 ways: as integral to claims advocating for the measurement, disclosure, or alignment of Scope 3 emissions, and as part of divestment or disengagement claims from project clients or sectors characterized by high greenhouse gas intensity. A slight majority of the cases were filed in domestic courts. Europe hosts the majority of the cases, followed by the US. Claimants tended to be NGOs, and in 3 cases, affected rights holders were also involved. 1 case was brought by the members of a pension scheme. So keeping this general outlook in mind, let's get a bit technical and analyze the 14 cases in more detail. I promise to try to bring along those of you who don't have a legal background. And to do so, I'll briefly explain the logic of international law. The biggest assumption we have in international law is that states are the subjects of international law. That means that international law is binding on states in their relations with each other and imposes duties or confers rights upon states. The status of non-state actors is a bit less clear, and it's still evolving. When it comes to companies, they may enjoy legally binding rights under international law, for instance, as foreign investors. However, Business is not viewed as possessing obligations, or in other words, duties under international law. Instead, companies are generally viewed as having responsibilities. I will also briefly explain the logic of human rights protection. Human rights are a series of rights and freedoms inherent to all human beings. How we protect human rights is basically by creating the status of a duty bearer and a rights holder. The duty bearer fulfills obligations towards the rights holder, and the rights holder claims rights from the duty bearer. Now, traditionally, states are the primary duty bearers. However, with the rise of multilateral companies, today we talk about human rights protection against the abuses by companies. So how do we provide protection against human rights abuses by companies? The UNGPs provide a framework for that. According to this framework, states have the duty to protect human rights, business has a responsibility to respect human rights, and victims of human rights abuses resulting from a company's activities must be able to access effective remedy. The OECD basically copy-pasted this framework in 2011 into the guidelines. So that means that affected rights holders can bring a claim before an NCP and use this mechanism to apply the UNGPs. Also, the UNGPs are and continue to be transposed into domestic law and regional law. So there could be other legal sources that can be used to enforce the UNGPs. So what does this framework really say? Well, it says that business enterprises must not cause, contribute to, or be directly linked to adverse human rights impacts. The UN Human Rights Body continues to issue guidance on the interpretation of the UNGPs. According to the guidance, a financial institution causes an adverse impact if its activities on their own are sufficient to result in the impact. For instance, a bank discriminates against women or racial minorities in its hiring practices. A financial institution contributes to an adverse human rights impact if its activities, in combination with the activities of other entities, cause the impact, or if its activities cause, facilitate, or incentivize another entity to cause the impact. For instance, a bank is financing an infrastructure project that entails clear risks of people being forcibly displaced. If the bank knew or should have known that risks of displacement were present, yet failed to take steps to seek to get its client to prevent or mitigate them, then it is contributing to that adverse impact. Finally, a financial institution can be directly linked to an adverse impact through its operations, products, or services by a business relationship. For instance, a bank is financing a client. In the context of using that finance, the client acts in such a way that it causes or is at risk of causing an adverse impact. So if a business enterprise causes or contributes to an adverse impact, then it's responsible for taking measures to mitigate or prevent the adverse impact and for providing remediation. If it's only directly linked to an adverse impact, then it is responsible for using leverage alone or in cooperation with other entities to influence the entity causing the adverse impact to prevent, mitigate, or remediate the adverse impact. In these scenarios, financial institutions can take measures such as shareholder proposals, engagement with the management, the threat of divestment or divestment, and disengagement. So with this knowledge, let's now analyze the 14 cases. There are 6 NCP cases which use the UNGPs and the OECD guidelines and other OECD guidance. The cases also take into account international standards, instruments, other NCP decisions, and domestic frameworks. There are 8 court cases. They use a range of domestic laws and regulations, as well as regional human rights law, such as the European Convention on Human Rights. They also discuss international standards and instruments, such as the UNGPs and foreign court decisions. Interestingly, these cases reference 3 landmark human rights-based cases in climate litigation, namely the Urgenda case, which compelled the Dutch government to reduce emissions by at least 25% compared to 1990 by the end of 2020, the Laghari judgment, which determined that the delay of the government of Pakistan in implementing the country's climate policy framework violated citizens' fundamental rights, and the report of the Commission on Human Rights in the Philippines, the CHRP, which advised financial institutions to refrain from financing fossil fuel-related projects to redirect capital towards green projects and exert pressure on the fossil fuel industry to transition to clean energy by divesting financial instruments related to the fossil fuel industry. So this table provides more detail on the NCP cases. Only 2 of the proceedings resulted in a successful outcome. And interestingly, these were the 2 cases that did not demand divestment or disengagement. Rather, they demanded the measurement and publication of Scope 3 emissions, the setting of specific and measurable goals, and reduction of emissions in alignment with the 1.5 degrees Celsius goal. As a result, ING Bank and Group PZU disclosed information demanded by the complainants. Only 1 case is currently pending, and that is the case against Marsh. Here, NGOs are claiming that Marsh, as an insurance broker for EACOP, the East Africa crude oil pipeline, is not just directly linked to, but also contributes to adverse impacts. They demand that Marsh seizes its role and provides remedies to victims. Importantly, the complainants are relying on the full value chain emissions of EACOP, which they argue contradicts the Paris Agreement goals. The local organizations had also filed a human rights-based claim to stop EACOP from being built before the East African Court of Justice, which was recently dismissed for being time-barred. So the outcome of the NCP process remains critical for affected rights holders to have access to remedies. Looking at the court cases, it's possible to see that all cases demand divestment and disengagement, as well as measurement, target setting, and steering. The only success achieved so far was the strategic litigation of Client Earth targeting EU's CSPP, Corporate Sector Purchase Program, which we mentioned before. There are 2 unsuccessful cases, and these concern the members of a climate activist group called Break Free Swiss. The activists face criminal charges due to their actions during the protests against Credit Suisse, which is a bank. Well, it used to be a bank. In one of the protests, the activists got a bit creative. They dressed up and staged a tennis match, blocking the entrance of the bank to protest Roger Federer's involvement in the bank's advertisements. They demanded Credit Suisse to stop financing and investing in fossil fuel companies. So the activists faced several charges, including property damage and trespassing. They unsuccessfully invoked their rights to freedoms of expression, peaceful assembly, and association under the European Convention on Human Rights. They also argued that their actions could be justified under the Swiss Criminal Code as a legitimate act in a situation of necessity. The cases went all the way up to the Swiss Supreme Court. The judges of the Supreme Court concluded that climate change poses no immediate danger to an individual's specific legal interests. Therefore, the actions of the climate protesters could not be viewed as legitimate in a situation of necessity. In the court's opinion, climate change did not pose an immediate danger to an individual's specific legal interest. Instead, the dangers of climate change can strike everyone indiscriminately, without it being possible to identify a specifically threatened legal interest, according to the court. If the activists aim to defend collective interests, such as the environment and health of the population as a whole, then the court stated that these would not be acceptable grounds for this law to apply. Furthermore, it was not the case that the climate crisis was impossible to avert by means other than those employed by the activists. In the court's opinion, the activists had other legal means to express their demands from the bank, such as authorized demonstrations and media interventions. As a result, the activists had to pay fines. So on this note, I would like to now start concluding the presentation. I mentioned before that there were 8 cases filed in Australia. You can see that human rights were discussed only in one instance, in the case filed before the Australian NCP against ANZ Bank. The rest of the cases were based on other legal foundations, and a common driving force here seems to be the concept of ESG, environmental, social, and governance factors. Claimants have been using the ESG movement to claim more disclosures, better disclosures, and policy alignment with the Paris Agreement goals. We are witnessing shareholder activism here. For instance, the 23-year-old Mark McVeigh sued his super fund, as a result of which the fund, REST, agreed to adopt a net zero policy. 2 cases lodged by the shareholders of CBA discuss the exercise of shareholders' rights under the Corporations Act of 2001. The first case aimed to notify CBA of a proposed resolution for consideration at the annual general meeting. The proposed resolution offered 3 alternatives. CBA included the third alternative in the meeting notice, but excluded the other 2, citing them as matters within the purview of the board and the management of the bank. The first preference required the directors to provide a detailed report on emissions, as well as assessment of risks using a verifiable methodology. The second one expressed concern about the absence of such a report, and the third one introduced a special resolution to amend CBA's constitution, which would require the directors to report on emissions. So the applicants sought court intervention, including a declaration that the disputed resolutions could validly be moved at CBA's annual general meeting based on their legitimate interest in the subject matter. So the Federal Court of Australia rejected this argument, emphasizing that shareholders' legitimate interests in company management are distinct and cannot be aggregated to provide a justification for a resolution in a general meeting. The court maintained that a company's powers and capacities originate from its constitution and statute, not the legitimate interests of its shareholders. The court also did not agree that this case had far-reaching impact on shareholder participation or corporate governance. Regardless, the court's decision did not deter CBA from committing to climate action. In 2019, CBA announced its environmental and social framework, which included a commitment to provide banking and financing activity to new oil, gas, and metallurgical coal projects contingent on an assessment of their environmental, social, and economic impacts in alignment with the Paris Agreement goals. And concerned shareholders, based on this framework, filed a claim to exercise their right to access internal documents to assess CBA's involvement in 7 fossil fuel projects. They basically wanted to see if it was aligned with the framework, the environmental and social framework. So following the plaintiff's submissions and the CBA's admissions, the court, by consent, ordered CBA to provide specified documents to the plaintiffs. The proceedings concluded in 2023, so just last year, allowing the plaintiffs to use certain documents for potential future litigation against CBA, and to share these documents with Australian prudential and conduct regulators, potentially impacting future climate litigation. So zooming out of Australia, if we look at global trends, we are experiencing shareholder activism in climate litigation. This is likely to be a trend that might continue. We can clearly see that strategies are being replicated. This is partly due to international NGO networks bringing claims in several jurisdictions, such as Greenpeace, Climate Earth, and Friends of the Earth. We are observing a growing backlash against climate activists. I believe this trend will persist, especially in cases involving trespassing and property damage. Contact expectations from financial institutions are continuing to be developed. This is good news. Bad news is that this is happening in a proliferated manner, which will make it harder to order a global standard of conduct. Climate litigation risk in the financial sector is on the spotlight. We might see not just more measuring, target setting, and steering demands, but also divestment and disengagement demands. And finally, there is some discussions on whether an entirely new duty to stop contributing to climate change is emerging. This might be applicable both to governments and companies, even to financial institutions. The content and contours of such a novel climate duty might be developed by different courts in the upcoming years. So some thoughts for future research. If you find this topic interesting, we could prepare a piece together using the large data set. It could even be an MCF piece. So please feel free to let me know. If you're a climate scientist, and I believe we have some climate scientists at MCF, then you might find it interesting to focus on the methodologies to calculate financial institutions' emissions. This is so important. For instance, in the settlement of the proceedings against the Commonwealth, the claimant also had to agree that there is currently no internationally agreed framework for assessing any climate-related risks and opportunities associated with sovereign debt instruments. So contributing to international standards on such aspects is very crucial. So thank you very much, everyone. I think that was a lot. And I tried to make sure that I was not moving too fast, but maybe I was a bit fast. I will look forward to the discussion and your questions.
Wonderful. Thank you so much, Ailid. And it's a really interesting topic, and I think it's garnering a lot of international attention and domestic attention. So I would encourage people to put questions in the chat. We've already got one, and I've got a few questions myself, Aylin. So we might start with a question from Ben Neville. So the national contact points are notorious for being weak and only providing recommendations that companies ignore. Although the Australian one seems to have been strengthened in recent years, Ben's asking, do you have a sense of how effective it's been, or the national contact point in other countries?
Yeah, thanks a lot for the question, Ben. That's a very, very good question. So I think we still tend to be within the paradigm of companies are only responsible and we should, let them engage in the free market. Their responsibilities on human rights issues should not be that stringent because it's, difficult and hard to manage and so on. So this is still I think the legal paradigm in which we're in. And NCPs within that legal paradigm, I think they play such an important role, right? They play a very important role. They are weak. They're not the strongest. But I think especially the two instances where there was a settlement, or rather an agreement amongst the parties, it did bring about a new policy, both in Group PCU and in the other case involving, gosh, I forgot. Let me check which one that was. And ING Bank, of course, which was the first case that was filed. So in those two instances, they did bring a concrete policy change. So I do understand that we should be very critical of the NCP mechanism, but it is one of the best things that we have. And some NCPs have better reputation than others. I'm not 100% sure about the Australian one, but when it comes to the Dutch one, it does have a very good reputation. So there was a really big case that was filed against Heineken, and there the Dutch NCP played a really good role, and they even actually contributed to bring the rights holders from Africa to fly them into the Netherlands because, as you know, if you don't have the right passport and you don't have the amount of money to buy a plane ticket, then it will be virtually impossible for one to travel all the way to the Netherlands to, file a claim against a huge multinational company. So the NCPs can facilitate these discussions, and they can bring about a change. But that being said, in none of the cases that I found that were filed against financial institutions with respect to climate change and human rights issues, in none of the cases did an NCP actually say, oh yes, this financial institution is non-aligned with the guidelines. So in none of them do we see a decision that says, oh, this company is actually violating or not adhering to the guidelines. So the mediation or the conciliation aspect of the mechanism is indeed still quite weak.
Yeah, I think it's a great point you touched on there, Aylin. So I encourage others to pop in the chat as well. But Jackie Peel, who you mentioned in your chat, often talks about both the indirect and the direct consequences of litigation. Would you be able to talk a little bit more about, success in a case like this may not necessarily be a win in the courtroom? Would you be able to maybe talk about what actually does success look like? What can be the impacts of these cases? I mean, it's not just that. It's if you're able to elaborate a little bit more on that, that would be great.
Yeah, sure. I think the general one with climate litigation is that it brings awareness. It has the potential to even turn into a lucrative business, which means more people might invest in climate litigation. But with respect to, in particular, financial institutions, what we're seeing here is that these decisions are actually being used by different networks to basically advocate for policy change at the regulatory level. So one example would be the WWF, which is doing a fantastic work with its project called SUSREG, Sustainable Regulations. And they're basically assessing over 40 countries now how the financial regulators there, as well as supervisors, are actually providing rules and regulations on ESG issues, where they fall behind, and they're comparing each jurisdiction. There's even a tool online that everyone can access. If you just type in WWF SUSREG assessments, you'll be able to find it. And the visualization is also perfect. It's very easy to compare jurisdictions. So I think the biggest traction of climate litigation is the risk that is attached to it. Oh, what happens if I'm sued? And then with that risk, one turns into an institution like the WWF and says, okay, tell me what I should do, because you are the one who knows sustainable financial regulations and you have, assessed countries. Tell me what to do. So we are seeing more and more interest being, harnessed, and we are seeing more and more funding coming into these projects, which is very good news, but it's taking time.
Yeah, I think it's a great point to connect how litigation is just one tool in the toolkit, and it can be used as a tool of, I guess, policy change. So building on that, I guess, what do litigants want in these cases, do you think? Is it that policy change? What would success look like to them?
Mm-hmm. Yeah, I think if the case is solely lodged by an international network, it's slightly different than when the affected rights holders are involved, right? So if you have the affected rights holders involved, then I think those claims are really saying, hey, you got to pay remedies here. So they ask for remedies. If the case is lodged as a strategic claim by, let's say, Greenpeace or Klein Earth or Friends of the Earth alone, then it could be more about a general policy change and conduct change. So change the way you behave, change the way you set your targets and align them with the Paris Agreement, or change your disclosure because it is not effective enough, it is not good enough, or steer your policies and conduct to be aligned with the Paris Agreement, or divest and disengage in general with anything that is not aligned with the 1.5 degrees Celsius goal. So up there, they are less interested in compensation and more interested in conduct change and policy change, which is very immediate. And then it will hopefully have ripple effects in the whole sector, which is hard. But I would say that's more the aim there.
Yeah, and so I think Ben's popped in another question in the chat. I think it's a really great point around, that these cases are built into the larger ecosystem. So Ben said, you suggested that we're observing a developing duty. Can you elaborate on what that means and what obstacles there might be in terms of that duty?
A lot of obstacles. And I think the biggest one from a legal perspective, a legal theory perspective, is, do we actually want our courts to do this, right? We want our courts to interpret the law, to apply the law, but do we actually want them to be activists and to prefer one political or ethical consideration over the other, right? That is one of the biggest, I think, on a theory-wise criticism of this new potential duty that might be emerging. But with respect to the duty itself, what it is, as I've said, the contours and the content are not clear. There is a world court, the International Court of Justice, which now is on track of providing an advisory opinion on the duties of states, so governments, not necessarily companies, but it will have implications for companies, on climate change. So what are the duties of states to handle climate change, to address the climate change? What happens if they fail to do their fair share burden and just, don't act? And what happens if their national their contributions, their NDCs that are filed to the Paris Agreement, to the UNFCCC, are actually falling behind what they should be doing? So what happens? And honestly, we don't know, because the law that is created by states doesn't really say anything. So we will see the ICJ's advisory opinion having some influence on this. Otherwise, domestic courts are rendering decisions. So the Dutch one is very important, which was against Shell. And then Shell, it ordered Shell to reduce its global, so not just Netherlands-based, but global greenhouse gas emissions. And then Shell simply moved its headquarters to London, right? That was the response that Shell gave, and they appealed the decision. So is there a duty here for Shell to stop contributing to climate change? Well, you know, they are forum shopping. They went to London. Sure, another case was lodged in London against them, but this one didn't work out. So this just shows all the complexities that are attached to it. And the safest bet would be that we all come up with a rule at the global level that can then be implemented. And this has to be a legally binding commitment. And we do this, like in international, we're already doing this, right? WTO, World Trade Organization, it already has legally binding rules and regulations on the freedom of goods and services. So it's not like we have at the international level never achieved this. We have. We can do this. It's just the next step that we have to take.
I think it's a great point there. And sort of building on that, you say maybe we need to have a rule at this international level. You know, for example, it might be that financial institutions need to be aligned with the 1.5 degree pathway, something along those lines. How then, and one of the questions that litigants put, or demands that litigants are putting in these cases is for financial institutions to divest from fossil fuel projects. How do these cases then deal with the fact that actually we don't want these assets just to become stranded? We don't want them to be passed on to the lowest common denominator. We actually want them to be responsibly managed down to support the just transition. What sort of considerations are playing into these cases in that regard?
Mm-hmm. So I actually, in my article, I named this the ineffectiveness of exclusion argument. So basically there, the argument is if I stop investing in or providing financial services and products in XYZ companies or sectors, someone else will. And it's better that I do it because I do it better, right? I have some conditions attached when I provide these services. So that to me it goes back to the whole point of not having a global minimum standard of conduct. If there's no global minimum standard of conduct, you can get away with this argument. You can say, oh, it's ineffective for me to exclude that client or that sector because someone else will provide the service and they'll do a worse job. Well, if the playing field is leveled at the global level, then you can't really put that argument forward anymore. So the OECD has which you might be interested in, the OECD has a due diligence tool for institutional investors for managing climate-related risks. They just published it last year, and there they talk a lot about stranded assets. And divestment and disengagement in this climate risk tool is recommended only as a last resort measure, and they make sure that they include that inclusion of ineffectiveness, which is my phrasing, might not be a real thing, but that's how I frame this argument. They cite this argument and they say, hey, but if that financial institution doesn't do that job, someone else will, and they'll do it worse. Well, I would have expected a bit more critical engagement from the OECD, to be honest. But yeah, so this argument does exist. I'm not sure that it is a smart argument.
Yeah, it's all about working out how do we responsibly manage down these assets as quickly as possible so it's aligned with 1.5. Look, if anybody else has any other questions, please feel free to put them in the chat. And I guess one final question from me, Aileen, why human rights? Why do you think human rights are so important in terms of climate litigation?
Mm-hmm. So for me, it really goes back to the indirectness issue, right? The one that I tried to lay out at the very introduction, at the very beginning of the presentation, which might have been very heavy to begin with, but I think it really introduces why we need the human rights turn here. If we use only corporate law, if we use only ESG frameworks, which are, barely legally binding, and some jurisdictions they're binding, but they're not really mandating, well, we are seeing more regulations coming, especially in the EU. But I think the traction that human rights really has is that you can say, if you're directly connected, directly linked to a client that is in real economy, contributing massively to climate change. If you are that financial institution, then you have a responsibility to do something. And I don't see that connection being very easily made by using other grounds like torts law or corporations. It's harder. It's harder to, I think, utilize those tools. They are being used, and there are successes being made, right? Especially with shareholder activism in Australia, we have seen some, successful cases that led to settlements and led to some concrete policy change. But on a global scale, as a lawyer, I find the human rights turn very, very critical and very interesting here.
Yeah, so it's able to sort of draw that connection in, I guess, to make businesses really directly accountable. Are there particular human rights that you think are really tangible in this space?
That's a very good question. Life comes up a lot. So the right to life, a right to have a private life, comes a lot. Of course, calling for more stringent human rights impact assessments, which would then be sort of a blanket access to sort of all types of human rights that are internationally recognized, right? That comes up a lot. So I feel like, especially with the NCP cases, they're just saying, hey, you should have done a better job with your due diligence on human rights issues. That means everything that's internationally recognized, right? So our 9 core human rights instruments at the UN level, but also they may refer to domestic and regional regulations and frameworks as well. But I do see private life, right to life, and then food, water, and so on, that sustains our living to be the strongest points. They're also the hardest, perhaps, to show, because it's hard to say that somebody has died because of climate change yet. It's very hard. Climate scientists would know this better. So it's hard, but these arguments are being made. And if anybody is really interested in this, actually the Eni case that was lodged in Italy, it is a fascinating case to read. If anybody wants to read any case from the data set, it would be that one. So Eni is ENI, lodged in Italy in 2023. So take a look at that case and read the submission. It's a fantastic submission. It's very long, but fantastic. And it looks at all the NCP cases, all the international norms and regulations and human rights and domestic law issues in Italy as well. So fascinating links being made.
Yeah, look, we probably have time for one more question, Aileen, and then I might ask you to sort of wrap up, maybe if you've got some final thoughts. But Ben's got one final question about, there's also an alternative private court system for international corporate settlements. Have you observed that being used for climate cases?
No, that's a very good point. I haven't really looked at either the ISDS cases or other types of dispute settlement mechanisms. Would Ben have a suggestion on a case or a venue for me to look at?
It might be. I think we're on mute, but it might be the International Court of Arbitration, and those sorts of judgments might come through in the future.
Yeah.
And Ben said no.
Oh, okay. Yeah, no, the other venues, I really try to focus on the venues where I know the databases that are available are recording the case. Well, they're not recording all the cases that are happening everywhere, right? Some are, even with NCP cases, some we might not even see any of because they could be confidential. So it's quite hard to access, especially with other forms of dispute settlement, these kind of judgments or assessments, because they could be confidential, especially with ISDS, investor state dispute settlement mechanism as well. We're seeing the same, but there in particular, we're seeing that financial institutions are actually being the claimants, so not respondents. So very interesting. They're suing countries for climate policy and action. So fascinating things are happening, right? That's the double-edged sword of climate litigation being a tool. Anyone can use it as a tool, so long as they have the finances and, well, they have the heart put into it. So
totally. Look, Aileen, this has been a terrific presentation and super interesting. One final sentence. If you had to leave our audience with a final thought from your presentation, what would it be?
Really think about whether financial institutions ought to have some responsibility when they provide their services and products to real economy. Because the whole idea is they're the bloodline of the economy, right? They're the bloodline as in if financial institutions don't provide those services and products, then a certain certain sector of the economy will simply not exist, right? So I want you to think about that a little bit, because I think when they say we are only indirectly implicated in climate change, we're not responsible. The real economy should change, not us. They do have a point. So I want you to think about that, and it would be interesting to hear your thoughts after you think about that. You can email me, and I'll be interested to know whether you think the real economy should first change, or whether financial institutions and the real economy together should change, or how you see that burden, how that burden being distributed.
I think it's terrific, Aileen, and I think it's a testament to show you scratched below the surface in these sorts of issues, and there's a lot of complexity, but we need to be acting as urgently as possible. So thank you so much for your time today and for your insights. It's been terrific. And please, I would encourage anybody who would like to reach out to Aileen to reach out to her directly or through Melbourne Climate Futures and further. So thank you so much again, Aileen, and thank you to Melbourne Climate Futures for organising this. And we hope to see you in the next event.